Evening, ladies and gentlemen, and welcome to HKIAC's webinar on domain name dispute resolution. This is Sarah Grimmer, welcoming you in a rainy afternoon in Hong Kong. Today's webinar is on challenging a domain name, specifically with respect to the first element of the test in successfully challenging a domain name, and that being the proving the identical or confusingly similar requirement. This is the first webinar in a series of 3 webinars that we will be running. The next webinar will be in 2 weeks' time, and that will be on the domain name holder's rights or legitimate interests in registering a domain name. And then the third webinar will be held 2 weeks later on the 14th of September, and that will be looking at proving a respondent's acting in bad faith. So for the next 6 weeks in total, every 2 weeks on Monday at this time, we will be looking in depth at the 3 elements that are required to establish a successful challenge of a domain name. And also to let you know that this series will also be run in Chinese. We will start that in September, and the dates will be announced shortly. Today's webinar will be recorded and the slides will be made available afterwards. They will be sent to all attendees, but also available on our AV library, which is available on our website. Now today's webinar will consist of 3 short presentations. First of all, I will talk a bit about HKIAC's work in domain name dispute resolution, and then we will hand over to our 2 guest expert speakers. And then the last part of the webinar will be dedicated to a discussion time dealing with your questions. So please do send in your questions through the messenger function, and we'll get to those towards the end of the webinar. So without further ado, let me introduce our 2 expert guest speakers. First of all, we have with us Professor Kun Fan. Professor Fan is an associate professor at the University of New South Wales in Sydney, where her teaching and research focuses on international arbitration, mediation, comparative legal studies, and cultural study of law. She was an associate professor at the Faculty of Law at McGill University in Canada, and she also taught for 7 years at the Chinese University of Hong Kong and was a visiting scholar of the Harvard Yenching Institute at Harvard University. She has extensive experience in arbitration as counsel, legal expert, secretary to tribunals, arbitrator, and in her role at the ICC Court of Arbitration. And she is also a domain name disputes panelist at the HKIAC and with the Asian Domain Name Dispute Resolution Center. Today, Professor Fan will discuss the two-part inquiry of the first limb, first by looking at scenarios in which a complainant can establish rights in a trademark even if they have not registered a trademark per se. And then she will look at cases where the confusingly similar or identical threshold has been met or has not been met, in cases where the domain name involved, for example, additional terms to the trademark, whether those were generic or descriptive terms or geographical descriptors, or where there may be misspelling or typo squatting involved, and also with respect to the use of acronyms. Our second guest expert speaker is Mr. Sebastian Hughes. He is a barrister at Prince's Chambers in Hong Kong, originally qualified in Victoria, Australia in 1998 and admitted in Hong Kong in 2003. He has a broad civil litigation practice, including intellectual property, commercial, white-collar fraud, insolvency, company, employment, matrimonial finance, and costs and taxation matters. He has been frequently ranked as a leading barrister for intellectual property matters. He is a fellow of the Chartered Institute of Arbitrators and a WIPO approved neutral. He is an arbitrator and mediator with WIPO and with HKIAC, and with HKIAC specifically on our panel of arbitrators for intellectual property disputes. And he is a domain name panelist with WIPO, Forum, HKIAC, the AD&DRC, and AIAC. He is also a fluent Putonghua speaker and renders decisions in English and in Chinese. Sebastian's presentation is going to focus on the relevance of the top-level domain in the confusingly similar identical examination, as well as how this limb of the test interplays inherently with the second and third limbs of the test, specifically around timing and the use of generic terms. And he will also discuss issues raised by translations and transliterations of trademarks, including the use of Chinese pinyin, and also the relevance of the content of websites. Before we hand over to our guest experts, let me provide some information on HKIAC's work in the domain name dispute resolution field. Next slide, please. So HKIAC provides domain name dispute resolution services under all of the policies that you see in the slide in front of you. So there are many, but what I want to focus on is three, those being the UDRP, the HKDRP, and the Cndrp. As you will all know, the UDRP is the policy where organizations accredited by ICANN process the registration of domain name disputes under the UDRP policy. And there are five accredited UDRP service providers, one of which is the Asian Domain Name Dispute Resolution Center. And HKIAC helped establish the ADNDRC back in 2001. The ADNDRC has 4 offices operating in Asia: Beijing, Seoul, Kuala Lumpur, and Hong Kong, and HKIAC is the Hong Kong-based office. The HKDRP is a policy incorporated by reference to the agreement required by the Hong Kong Internet Registration Corporation Limited, and it relates to disputes that concern the .hk and the equivalent Chinese symbol, country code, top-level domains. Cndrp is the policy promulgated by the China Internet Network Information Center in 2006, which was updated last year, and that governs disputes relating to .cn and the Chinese equivalent for those country code top-level domain names. Next slide, please. To give you an overview of the kind of work that we are involved in, you'll see here statistics from the last 5 years. And what is striking is that by far and large, the most cases that we handle each year are UDRP and Cndrp cases. Last year, approximately 58% of our cases were UDRP cases, so we were acting in our role as the Hong Kong office of the ADNDRC, and 38% were Cndrp cases, with 4% of cases coming under the HKDRP. And this is a typical annual breakdown for HKIAC. But what you can also see is that we deal with hundreds of cases every year. So from our position as a service provider, we have a very important vantage point in terms of overseeing hundreds of domain name disputes every year, seeing the work of domain name dispute resolution panelists and how the process plays out. Let me share with you some more statistics. Next slide, please. So where do the parties in our cases come from? From last year, you can see that parties came from 34 jurisdictions across all of our cases, and the top 10 geographical origins are listed there. They were widely spread across Asia, the US, and Europe. And then if you look to the right, you can see the split between where complainants came from and where respondents were from. And you see that with respect to complainants, the most common user were complainants from the United States and then from mainland China. And then what is also a striking statistic is that from the respondent jurisdictions, by far and large, the most common respondent in the cases that we see were from mainland China, and then following up quite a way behind, the next most common were from the US, Hong Kong, and then a couple of other jurisdictions. Next slide, please. We see a large number of cases in the Chinese language. Last year, 63% were run in the Chinese language and 37% were run in English. Many of the cases that were run in Chinese also had English language elements. So what that means for HKIAC is that we need to draw from a large pool of bilingual panelists. What is also interesting is we've seen a few other languages come through in cases recently. So in 2020, the first half of this year, we also saw Japanese, Korean, and Russian. And for Korean and Russian, we have on our staff proficiency in those languages, so we were able to provide full support in those languages, both to the parties and to the panelists. But that also gives you an idea of, as a service provider, what services we need to have on, what proficiencies we need to have on our staff at all times to make sure that cases can be run well. Next slide, please. In terms of appointments, last year we made just under 200 appointments. You see how those are split across the different policies, but the main takeaway is that in 97% of cases we appointed a sole panelist. Only very few cases required the appointment of a 3-member panel, just 5 last year, and that is how it is usually for most years. And then on the right-hand side, you see a list of the geographical origins of panelists. And you see that at number 1, we have Hong Kong. And this very much ties back to the language requirements that I spoke about earlier, and that we do need to draw from a large pool of bilingual candidates. And we find that Hong Kong does have a large pool of bilingual candidates. Next slide, please. This slide shows you the outcome of cases across 2019, and it will come as no surprise to most of you that there is a very high rate of success. If you average across all of the decisions rendered, 180 or 95% were decisions to transfer, so that's a 95% success rate. 2.5% of decisions were to cancel the domain name, and in those cases, the decision to cancel was at the request of the complainant, and those cases were related. There is a very small proportion of cases where the transfer of the domain name is denied, 2.5% across all cases. And those cases that are denied typically fail on the requirement to establish rights to a trademark, which is something that we will be talking about in this webinar, or on the requirement to establish bad faith on the part of the respondent. As you all know, decisions are available online and they are open to the public. And that is part of the service that HKIAC and other service providers provide. Next slide, please. And just to close, I will go over what services we do provide. The main and the most important service that HKIAC provides is appointing panelists in DNDR proceedings, ensuring their availability, the appropriate language abilities, their independence and impartiality. But we do also monitor very closely the whole process from beginning to end, and we act as a conduit for communications between all participants in the process. So to take you through quickly the process, when we receive a request to a domain name complaint, the first thing that we do is we contact the registrar and request them to lock the domain name so as to maintain the status quo and to confirm the respondent's contact information. What then follows is a review of the complaint for compliance with the policy, the rules, and the relevant supplemental rules. And then we give notice to the respondent of the complaint, which then triggers their time period within which to file a response. And there going forward, we act as a conduit for communications. We monitor the process according to timelines. So we move the moment a timeline has finalized or expired. And then we appoint panelists when necessary within 5 days of receipt of the response and transmit the file immediately. We then monitor the timeline for the panelists to render their decision. And once rendered, we notify that to the parties and of course to the registrar, who will then implement the decision after 10 business days, which is the time period within which the respondent may file an action in domestic courts, and also to ICANN. We then close out the proceedings by finalising the panelist fees and also, of course, publicising the decision, whether that be on HKIAC's website or on the AD/NDRC's website. And on both websites, you will find, of course, a treasure trove of decisions that have been rendered by many panelists in English and in Chinese, and that will, of course, provide counsel parties and panelists with very useful information as to how to manage the process. So that's all from me. Next slide, please. And what I would like to do now is to hand over to Dr. Kun Fan for her presentation. Thank you.
Thank you very much, Sarah, for the generous introduction. Thank you, HKIAC, for the kind invitation. So good afternoon, ladies and gentlemen, and thank you everyone for attending this webinar. So as Sarah has kindly summarized, and in this short presentation, I will first discuss the rights that are covered under different DPR rules, and then give some examples of the circumstances where the panel has found the threshold been met or not been met. So we can turn to the next page, please. It is well accepted that the first element functions primarily as a standing requirement for the threshold test. Essentially, there are two parts of this inquiry. So the first stage of inquiry is whether the complainant has demonstrated that it has the prior rights. And the prior rights is defined slightly different under the different rules. So for instance, under UDRP, it's defined as trademark or service mark in which the complainant has rights. Under Cndrp, the language is the name or mark in which the complainant has civil rights or interest. And under the HKDRP, it says that the trademark or service mark in Hong Kong, which the complainant has rights. So we might come back to later how this have impacted the panel's decision. And if the first element is met, then the second stage of this inquiry would require a visual, oral, or conceptual comparison of the disputed domain to the proven prior rights in order to determine if it is identical or confusingly similar. The next slide, please. So in this slide, I gave some examples of the right that can be covered under the different DPR rules, including the names of natural persons, and in some cases, unregistered trademark. So for natural person, an interesting case is the PabloEscobar.com case, and the complainant in this case is Pablo Escobar's heirs. They sought to obtain the transfer of the domain name PabloEscobar.com 20 years after its registration by a third party in 1999, noting that filing a UDRP complaint is not subject to any time bar. And here also the registration of domain name was in fact much earlier than the trademark Pablo Escobar was registered in 2017. So as is often the case with celebrity squatting, it is therefore necessary for the complainant to demonstrate the existence of a trademark prior to the registration of the domain name. And to this end, Escobar Inc. has actually demonstrated the rights in the Pablo Escobar mark under the common law from its long and continuous use in commerce and development of the mark in the marketplace dating from 1986, supported with hundreds of millions of dollars injected into the market, which respondent did not deny, and the panel have actually acknowledged such rights. Of course, the panel did not go on to discuss the legality of such business. And so we can turn to the next slide, please. What about then the unregistered or common law trademarks? Well, under the UDRP, to establish unregistered or common law trademark rights, the complainants must show that its mark has become distinctive identifier, which consumers associate with the complainant's goods or services. But under the Cndrp, the matter is a bit more controversial. As I said earlier, Article 8 of Cndrp requires the complainant must have civil rights or interest in its name or mark. So some panel consider that an unregistered trademark generally falls short of the necessary proof in the .cn cases. However, the language used also does not contain a restriction that specifically limits its reach to only registered trademark. So unregistered trademark have also been found to support standing to proceed in some Cndrp cases. And here I listed some contrasting examples. In the case of google.com.cn, which was decided in 2003, and that was a CITAC case, And the panel actually rejected the prior rights of Google because it considered the company name has not been used in China and the trademark was not registered in China. It also considered that registration of google.com does not exclude other users to register google.com.cn. So this is one approach. That's more a territorial approach, which gives standing only to the owners of trademark that are registered in China. And in some other examples, more recent examples, such as the two cases I listed here, the HKIAC case, some panel took a more liberal approach. For instance, in the supreme.com.cn case, which I was involved as a presiding panelist in a 3-member panel. In fact, it's a very controversial case, particularly with respect to the procedure issue. So we had a lot of discussion among ourselves, notably whether the transfer constitute a new registration and thus reset the time bar under the Cndrp, which, as you know, was changed from 2 years to 3 years in 2019. And and we wasn't able to come to a consensus. So there was a well-written dissenting opinion in light of Cynic's email reply. But on balance, the majority, we decided the transfer would constitute a new registration and therefore it is not time barred. And the email from Cynic, which was not made to the public, did not constitute an interpretation under Article 20 of the Cndrp. And that decision allowed us to then proceed on the merit, and we were able to reach a consensus on the merit. So on the first element, we decided that the civil rights and interests under Article 8 of Cndrp, in fact, is not limited to trademark registered in China, but also include other rights protected under the Chinese law. In this case, even though supreme is a generic but not descriptive term, but through complainants' significant investment, the panel considered it has become distinctive identifier which consumer associates with the complainant's goods and services. We consider a number of evidence such as the duration and nature of the use of the mark, the fact that the trademark Supreme has been registered since 1994 in a number of countries, the amount of sale, nature, extent of advertising, and degree of actual public recognition in China. So there was evidence of numerous media reports and search results under Baidu. So I think this case is to be distinguished from the other case I listed here, the PacificAliens.cn, in which the complainant is a company registered in Hong Kong, but has not provided any evidence of its presence or business activities in China, nor did it have any trademark anywhere in the world in relation to Pacific Aliens. In this case also, the fact that the respondent is shown to have been targeting the complainant's mark by way of trademark squatting and also selling counterfeiting goods also supported the complainant's assertion that its mark has achieved significance as a source identifier. So I know this is still a controversial topic, so I'm happy to come back to the discussion later. So I'm more inclined to take the approach that whether unregistered trademark constitutes civil rights and Article 8 of Cndrp will depend on if such mark have received significant recognition or influence in China because of commercial use and advertisement. And if the mark are comprised solely of descriptive terms, then there would be a greater onus on the part of complainant to present evidence of acquired distinctiveness. We can turn to the next slide, please. So in this slide, I give some examples where the panel has found the threshold been met. And generally, the top level domain, be it the traditional GTLDs or CCTLDs or those new GTLDs like .brand, .club, is generally disregarded under the first element confusing similarity test. Although exceptionally, where the applicable TLD and the second level portion of the domain name in combination contain the relevant trademark, panels may consider the domain name in its entirety for the purpose of the confusing similarity test. Where the relevant trademark is recognizable within the disputed domain name, the addition of other terms whether descriptive, geographical, pejorative, or meaningless, would generally not provide a finding of confusing similarity under the first element, although the nature of those additional terms can be relevant to the assessment of the second or third element. So here I give some examples. For instance, again, in the pptu.com that I was the panelist. In this case, the complainant has registered the trademark as PP, PP Live, or PPTV in China, which include both the text and design. Even though PP include the figurative features, but the text PP is clearly recognizable here. And the second level portion of the domain name contains the entirety of the registered trademark PP. So I decided the addition generic term TU, which is opinion of the word sport, is not sufficient to avoid user confusion. And similarly, in some other cases, the addition of generic term cloud or the geographical identifier such as bin hai tiandi does not confer sufficient distinctiveness to avoid the user confusion. Similar principle apply to the typo squatting. So a domain name which consists of a common, obvious, or intentional misspelling of a trademark are generally considered to be confusingly similar to the relevant mark for the purpose of the first element, because the domain name contains sufficiently recognizable aspect of the relevant mark. The next page, please. And here I give some examples where a panel has found the threshold not to be met. A first issue is the use of generic or descriptive terms. So the question, can a trademark owner such as the Sun prohibit third parties from registering domain names that are identical to those marks? Some commentators said that sun shines for everyone. We should of course recall that the panel's role is limited, so it has no power to decide on the validity of those marks, but a weakly distinctive trademark composed of descriptive words could pose challenge for the trademark owners to exclude usage in the domain name market. So one of the interesting cases that I was involved, also as a presiding panelist, is the haitao.com. There was a lot of discussions also among ourselves as to the first element, but we were able to reach a consensus and decided that confusing similarity test is not met in this case. One of the crucial elements we also consider is the need to take into consideration of the relevant market and the fact that both parties essentially target the Chinese-speaking consumers. So the domain name haitao.com and the registered trademark haitao must be compared by taking into account not only the visual similarities, but also phonetic similarities and their respective meanings. So visually, the two pairs have a similar spelling in pinyin and also a similar writing in the Chinese characters. But haitao and haitao do not have the same pronunciation. The Chinese speakers would agree that the tone is an integral part of the pronunciation. And also as to the meaning, we are of the view that the term haitao is generic and suggestive expression. According to Baidu Online Encyclopedia, haitao means offshore online shopping. So the panel considered that the domain name is not confusingly similar to the registered trademark haitao or tao. And as we also noticed that the respondent's name is haitao, and therefore he was also able to establish legitimate rights and lack of bad faith. Panels have also rejected confusing similarity, in some cases with the use of acronyms. In general, the shorter the acronym, the less distinctive it is, which then gives third parties the opportunity to defend themselves more easily in those domain name disputes. So I will just conclude with a piece of advice, perhaps for the trademark owners. We live in a globalized environment, so it's really advisable not to choose a trademark that could be considered generic or descriptive. And for owners of those weak trademarks, I think there are two options: either to change the brand name Of course, that could be expensive, but there are successful examples of rebranding or proactively securing the domain name portfolio to register as many top-level domains as possible. So I will just stop here, and I'm happy to address any questions that may arise later. Thank you.
Thank you very much, Dr. Fan. That's a very interesting presentation going over some of the issues that are controversial or live and still at play for many trademark owners or those who have interests in a mark. Just a reminder to those attending, if you have any questions that you would like to pose to our panelists, please go to your Q&A button and submit your question, and we'll come back to those later on. So let me now turn to Sebastian Hughes for his presentation. Thank you.
Thank you, Sarah, and thank you, Dr. Fan. Next screen, please. My first slide is really following on from a topic that was already addressed by Dr. Fan. So perhaps it will hopefully supplement what has already been discussed. The point that I wish to make here is that traditionally, of course, the top level domain, so the letters that come after the dot, is disregarded when panelists are considering confusing similarity. So this is the general rule that traditionally has applied to all top level domains, including the traditional TLDs, new GTLDs, and of course country code TLDs. An example there is the Rexel Developments SAS and Jianye Chun case, WIPO case D2017 of 275, Rexel.red transfer decision. The .red GTLD was not taken into account in accordance with usual practice. It can, however, be of relevance when the panel is assessing the second and third elements under the policy. In other words, whether the respondent possesses rights or legitimate interests in the domain name. And secondly, whether the domain name has been registered and or used in bad faith. So in the De Beers .feedback decision, the fact that the .feedback TLD related specifically to feedback relating to the brand was a relevant issue that was taken into account in relation to the second and third elements. Finally, what's interesting, perhaps in more recent years in UDRP jurisprudence, is the fact that some panelists have, I think quite correctly, been willing to be flexible and essentially disregard the dot if the letters or word after the dot is relevant to assessment of identity or confusing similarity, then the TLD will be taken into account. So the final example there is the total dot jobs decision, a transfer decision where the relevant complainant's trademark was total jobs. Next slide, please. The next topic I wanted to address was what happens when the date of registration of the domain name predates the complainant's relevant trademark rights. And of course, as Dr. Fan has already indicated, the requirement on behalf of the complainant is to demonstrate either registered or unregistered common law rights, or certainly unregistered rights in civil jurisdiction at the time of filing of the complaint. So for the purpose of the assessment under the first link, the date of registration of the domain name and the date the complainant obtained its relevant trademark rights is immaterial. However, it is extremely difficult for a complainant ultimately to prevail in establishing the second and in particular the third limb under the policy, for the simple reason that usually bad faith under the third limb is premised upon a finding that the respondent is targeting the complainant or targeting the complainant's trademarks. And if the domain name is registered before the complainant has obtained any relevant trademarks or trademark rights, then it will be impossible for the complainant to demonstrate any targeting in respect of such non-existent trademark rights. There are some established exceptions, of course. The first is an opportunistic registration, where, for example, there's been an announcement of a launch of a new brand or of a corporate merger, and somebody quickly goes and applies for a domain name before the complainant is able to obtain its registered trademark rights. An example here is the waterpick.com.hk decision. This involved facts where the Hong Kong distributor of the Waterpick trademark, when it was appointed some years previously as the exclusive distributor in Hong Kong, registered the waterpick.com.hk domain name. Next slide, please. The complainant's Chinese language mark had at that time already been registered in Hong Kong, but the English language trademark was not registered at the time the domain name was registered. When the distributorship was terminated, it then refused to transfer the domain name to the trademark owner, and the complainant commenced the HKIAC proceedings, which were ultimately successful. One of the interesting points here is that under the HKIAC, there is a requirement that the relevant corporate entity has to be a Hong Kong entity. So one of the novel ways in which complainants have been able to comply with this requirement, if they're an international company, a company that's not based in Hong Kong, some panelists have been willing to accept a Hong Kong solicitors firm holding the domain name essentially on escrow for the overseas trademark holder. And that is what happened in terms of the waterpick.com.hk decision. The domain name was transferred to be held by the Hong Kong solicitors of Waterpick. Another example there is the nationalredress.com and nationalredressscheme.com decision. The respondent in that case was a solicitor in Australia specializing in representing victims of sexual abuse. And following a royal commission that was held in Australia, there was an announcement by the government that it would be setting up a national redress scheme in order to assist with processing compensation and redress for victims. This was also a transfer decision. And what transpired was that the solicitor, being aware of the impending setup of the scheme, himself chose to register those two domain names in issue. The second exception is where the domain name registration is transferred to a new registrant after the complainant has obtained its relevant trademark rights. And it's well established that a transfer to a new registrant is considered a new registration for the purposes of the UDRP. In the context of the Cndrp, increasingly we're seeing that panelists are willing to apply the relevant provisions under the Cndrp, which don't specifically address this issue, but Article 9 in particular talks about bad faith purpose of registration or acquisition of a domain name. And other relevant references in Cndrp to either registration or acquisition by a respondent has led some panelists to accept that in the context of Cndrp, a new transfer to a new registrant essentially is the relevant time for assessing complainant trademark rights. Next slide, please. Okay, so generic terms are usually disregarded when determining confusing similarity, and I'm repeating with apologies Dr. Fun's earlier slides and comments in this regard. There is an example here of valeropetroleum.org, a transfer decision where, not surprisingly, the petroleum component of the domain name is disregarded. As for the second and third limbs, whether or not a complainant is going to prevail or a respondent will prevail usually depends on the manner in which the domain name is being used. If it's being used in a generic sense, or if it's a dictionary meaning, a dictionary word being used in that sense, then it may be that the respondent will prevail. If, however, it's being used in any manner to essentially target the trademark rights of the complainant, then not surprisingly, the complainant will prevail. Next slide, please. This is an example, wallpaperdirect.com, a denial where the complainant was operating solely in the United Kingdom under wallpaperdirect.co.uk since the year 2000. The respondent registered wallpaperdirect.com in 2002, and 8 years later, the complainant filed a complaint. There was no evidence that the US-based respondent had ever heard of the complainant, but in terms of the use of the dictionary word wallpaper, it transpired that the respondent had a business of registering over 140 domain names comprising this term in order to generate pay-per-click revenue. So on the facts of this case, the respondent had rights or legitimate interests and was not targeting the complainant, the UK complainant's trademark. Next slide, please. This is a very interesting topic in terms of when and how a complainant is able to establish confusing similarity, where there is a translation or a phonetic transliteration of its trademark comprised in the respondent's domain name. An example is where the domain name contains pinyin or Romanized Latin text versions of Chinese language trademarks. So, for example, in the case of Remy Martin, the famous cognac brand, in Chinese, the trademark is Ren Tou Ma. And in this HK decision of rentoma.com.cn, a Cndrp decision administered by HKIAC, the domain name in question was clearly essentially identical to the pinyin Romanized version of the Ren Tou Ma trademark. So hence transfer was ordered, the other elements being made out. Another example is the alsalang.com decision, where the complainant was the well-known Osram light bulb brand. That case was less clear-cut in terms of confusing similarity, because the pinyin of the Chinese language trademark for Osram is O-U-S-I-L-A-N-G, and the mark Alsalang is certainly not identical to the Alsalang component of the disputed domain name in that case. However, the second and third characters in the mark that the respondent asserted it was using or it intended to use were identical to the second and third characters in the Osram Chinese language mark. And bearing in mind, and I think agreeing with Dr. Fan and her certainly majority panel's decision, perhaps in one of her earlier cases, that certainly the pronunciation and the meaning are important considerations. I think in this case, there is a similarity perhaps orally between the OU and the AO rendering and pronunciation of the first two marks. So perhaps it was more an oral rather than directly the meaning of the marks in question that got the complainant over the line. Next slide, please. Another interesting topic is whether the panel can take into account content on a respondent's website in determining confusing similarity. And as Dr. Fan indicated at the outset, usually not. It's usually simply a side-by-side comparison between the wording component of the complainant's trademark and the relevant content of the domain name. However, if it's a borderline case, panels have found that they can have a look at the respondent's website if that will assist in tipping the balance either way. An interesting recent case where the complaint was partially successful and partially denied is cnavl.com and cnavx.com. The complainant's mark there was AVX, and as Dr. Fan indicated, where you have an acronym mark, a 2 or 3 letter mark comprised in a domain name, it can be considerably more difficult for complainants to prevail. And that was the case here in the context of the cn-avl.com domain name. The panel considered that the AVL component was really not close enough to AVX. And there was an attempt made by the complainant to rely upon the evidence of website use in order to essentially to not to tip the balance, but really to try to get over the line and argue that, well, essentially the website is was said to be doing something together with AVX, but the facts didn't bear that out. Next slide, please. Oh, well, that's the end of my presentation. So thank you very much to HKIAC and to Sarah and to Dr. Fan. And I think now it's time to address any questions from the audience.
Thank you very much, Sebastian, for taking us over those issues. We do have questions that have flowed in, so I will start with those. I will start with Professor Fan. We have a question which is whether panels should consider well-known trademarks only if it is recognized as such under Chinese law. Do you have anything to add from your presentation to that question?
Sure. Yeah, that was a great question, actually. So I think that involves the first question, I guess, is the effect of national law. Right? So I think the general consensus, the UDRP proceedings is designed to operate in a global context. So under UDRP proceedings, generally the panel would not refer to any national laws in a particular jurisdiction, whereas the Cndrp or HKDRP proceeding, I think, are different because they're enacted to protect domain names that are registered in a specific region. So many of the panel would consider the interpretation of Cndrp should be consistent with the Chinese laws. And therefore, this well-known trademark is in fact a particular term under the Chinese law. So there are very specific criteria for the recognition of well-known trademark under the trademark law in China. I think it was Article 14 of the trademark law. And therefore, I think unless the complainant could provide evidence to prove that their mark is specifically recognized as a well-known trademark under the Chinese law, which in one of the cases, I decided like IBM.cn, that IBM was indeed furnished evidence to show that the trademark office in China have recognized it as a well-known trademark. But otherwise, I think the panel will generally not consider the protection of the well-known trademark. I think that was also the approach in the earlier slide. I listed the google.com.cn case that the panel decided that they will not consider protection of well-known trademark because complainant did not furnish such evidence. Having said that, though, I think in practice, though, if the complainant could demonstrate that unregistered trademark has received, like I said earlier, significant market recognition in China, there might still be possibility to prove the standing even for the unregistered trademark.
Thank you. If we just stay on this topic before we move to some of the other questions, we have a related topic which goes back to the tips, your takeaway points at the end of your discussion, and the question is this: for companies with no businesses in mainland China, such as Google, what advice would you give to them to protect their IP rights, especially when filing a Cndrp complaint?
I think in those cases, well, it's certainly advisable for them to really proactively manage the domain name portfolio to register as many top-level domains as possible. And so so in that case, if they fail to really register, then there would open up some possibility for the cyber squatting. And if they wanted to file the claim before to file the domain name challenges, I think it's important evidence the panel would look into is also the significant market recognition, whether whether there would be causing confusing similarities by the users. So the important evidence of like the market recognition in China would perhaps help their case in their domain name challenge. But as a preventative advice, it's certainly advisable for them to be more proactively handling those domain name portfolio to register as many of the trademark as well as the domain name, the top level domain name, preemptively to avoid that situation. But as I said, in some cases, the evidence of their significant market recognition can also support their case in the domain name disputes.
Thank you. If I can now turn to Sebastian, we have a question with respect to third level domain and second level domain protection. So the question is this: is it possible to bring a dispute name complaint for a party's trademark being used in the third level domain, but not the second level domain? For example, www.trademark.secondleveldomain.com.
Thank you, Sarah, and thank you to the attendee. The simple answer is yes, and I guess it gets back to the principle that I think both Dr. Fan and I addressed, that as long as the domain name contains the complainant's trademark, then that's usually enough to get across the line. There have been, for example, a number of cases where, in fact, there have been two trademarks combined of unrelated entities in a domain name, and that's been held to be confusingly similar to the trademark of the complainant that decides to pull the trigger on the proceeding. So the short answer is yes, because you have the trademark comprised within the disputed domain name, then that would satisfy the first limb.
Thank you. Another question we have here for you, Sebastian, is: do any of the three elements carry more weight than others? Is the first element hardest to prove?
Thank you. Well, that's a very interesting question. Perhaps to address the second question first, I think it's probably fair to say that the first element is usually the easiest to prove. And that's because, as we said earlier, it's usually a standing requirement based upon a side-by-side analysis of the text component of the complainant's trademark and of the domain name. So usually the first limb is actually the least controversial of the three limbs and the easiest to prove. But in terms of the three limbs, all three of them need to be satisfied. So they don't really carry any more weight than others. If you're a complainant and you're unable to establish all three limbs, so confusing similarity, the respondent has no rights or legitimate interests in respect of the domain name, and the respondent has not registered and or used the domain name in bad faith, then you won't prevail. 2 out of 3 is not enough. You need to establish all three.
Thank you. Then we have another question for Dr. Fan. In what language should the complaint be made? That's the entire question. So,
thank you. That's actually a great question, because that question often comes also in the proceedings. So there are the different rules has provided the default language. For instance, the UDRP said the language should generally be the language of the registration agreement. Cndrp, the default is Chinese, and under HKDRP, the default is English for the English.hk domain name cases, and Chinese for the Chinese.hk cases, but subject to the parties' agreement or the panel's decision otherwise. So there are sometimes the party might request a change of that language for efficiency purposes. So in those requests, generally the panel will have to take into account a number of factors. If there's a request made, usually the panel would also invite a response from the respondent to see if there's any reasons for those objections. And if there are objections, the panel will need to balance, on the one hand, the need of efficiency of the procedure, taking into account the actual translation and potential delay of the proceeding, and on the other hand, due process to make sure the party have opportunity to present their case. So usually they will look at, the respondent familiarity with the complainant's language, the content of the website, and also the evidence that are submitted to make a decision on the language.
thank you very much. I have a question now, I think, for Sebastian. We've talked quite a bit about the language within the Cndrp and what that means. And what I'm referring to is the identical and confusingly similar requirement, which requires that the complainant's name or mark is one in which the complainant has civil rights or interests. And then if we turn to the HKDRP, we find that the language is that the mark, the domain name is identical or confusingly similar to, I quote, a trademark or service mark in Hong Kong in which the complainant has rights. Is this more strict than the Cndrp? Is it possible to successfully challenge a domain name in Hong Kong under the HKDRP without a Hong Kong trademark or service mark registered in Hong Kong?
That's a very good question. And from the top of my head, I might need to get back to you on that. And perhaps I could try and do some quick refreshing of my mind on that point. Because of course in Hong Kong, we have well-established system of common law rights, which however seems to suggest under the HKDRP that there's a requirement to have registered Hong Kong trademark rights registered in Hong Kong. So apologies, let me double check that point, and then perhaps if we're not able to get back in time with today's webinar, then perhaps the person who asked that question could follow up again with HKIAC or with me, and I'd be happy to properly answer the question.
Sure, thanks Sebastian, that's great. And I'll just remind everybody who's listening that these slides and the recording of the webinar will be available after this webinar. So everyone who's attending will receive a link to the webinar, and any questions that we don't get a chance to answer, I see that we've actually come to the end of our time, will be answered. So if you do have questions that perhaps you haven't had a chance to pose, please do send them in and we will make sure that those are answered. And again, as I said, the slides will be available going forward. So we are at the end of our time, so I will bring this to an end. And I just want to thank Professor Fan and Sebastian for their work, for their insights, which have been fantastic. And have gotten us off to a very good start for our first in 3 webinars, looking at some of the issues in a more in-depth way for those of you who are very experienced in domain name disputes and want to talk about some of these more live issues. As I also said at the start, we have the next 2 parts of our webinar series coming up, 2 weeks in between each webinar. So Monday, 3:30 p.m. in 2 weeks' time, we'll be doing the second webinar, and that will be looking at the second element and looking at a domain name holder's rights or legitimate interests. That's the 31st of August. And then on the 14th of September, again, Monday at 3:30, we'll be looking at the third element, which is acting in bad faith. All of those elements, of course, have many layers and many issues to them. So thank you everybody for joining today, and thank you again for our expert guest speakers.